And we'll stay with this story a little longer. Live to Los Angeles now, and Sara Azari, a criminal defence attorney. It's been a while. Good to see you.
Good to see you too, John.
Okay. Well, this was a 6-week trial, much longer than expected. A lot of evidence, a lot of testimony, and yet the jury came back with a guilty verdict in less than 3 hours. So was it just simply an open and shut case?
It actually wasn't, and I am absolutely stunned. This case, to me, and to a lot of, I've spoken to a lot of judges, legal scholars, it was cloaked with doubt. And what this very quick verdict tells me, John, is that this jury just couldn't get past the lie. The idea that Alex Murdaugh was at the kennels with his wife and son before the murders, within 5 minutes or so, according to the timeline of the state, and then lied about it. And what it also tells me is that the jury didn't really do an analysis of circumstantial evidence. You can't possibly put every piece of circumstantial evidence in this case within the instructions and then come up with the verdict in 2.5 hours. I think what happened here is that once Alex Murdaugh testified, this jury had made up its mind. And this was just a matter of taking votes today. I'm absolutely shocked.
He didn't have to testify, right?
He did not have to testify. That's a defendant's right to invoke or not. I understand from his attorneys that he was absolutely adamant about testifying. They were sort of on the fence for a long time about whether he should or shouldn't. And why that matters is, number one, he almost had to, because he had to explain himself and he had to try to humanize himself. In hindsight, it probably wasn't a great idea. And what that means for his appeal, John, is that even though he has a lot of different good grounds for appeal, like the admissibility of all of this financial crimes, which was really character assassination for him, the lying, the conning, the cheating, the stealing, because of his testimony, a lot of things could be harmless error. So it really boxed him in terms of appellate issues. But I think one grounds that his team can pursue is the idea of the admissibility of anything and everything that had to do with him stealing from clients and friends. And it was really, at the end of the day, not about the theft and the motive, more about the lying, that he looked these people in the eye and he lied to them, and therefore the prosecutor was able to tell the jury, he's looking at you in the eye and he's lying to you. You can't believe a word he's saying.
There was that one key piece of evidence, which was the video recorded by the son, which put him at the crime scene just minutes before it actually happened. And that proved the lie. If that didn't exist, though, if that hadn't been found, is it likely he would have walked free?
I think, John, had that not been found, the state probably wouldn't even have a case. Because if you think about it, they had no physical evidence. They had no science. It was the defense that brought the science into this case, or the lack of science. And so it was, but for that video and the fact that he didn't disclose being there, when he was asked, he didn't say he was there. What was the last time you saw your wife and son? He didn't say he was there. That is what really did him in. And, and listen, I've had my heart broken by juries over and over. I've fallen in love with them over the years. But the jury's spoken. I respect the verdict. I, however, don't think it's the right outcome.
Well, the sentencing phase begins in a few hours from now. Why did the prosecution decide back in December that they would not seek the death penalty here?
I think this was really about the takedown of Murdoch. This is a small community. He had done a lot of people wrong. And obviously there's a lot of financial victims around him. The prosecution, if he was found not guilty, and even if there was a hung jury, they weren't going to retry him on this, then they would seek LWOP, which is allowed in South Carolina, on the financial crimes, because they have a very strong case. They didn't have a very strong case beyond a reasonable doubt on the murder side. But now that they're going to get the LWOP, they're getting what they wanted.
What is that in particular? The LWOP?
The LWOP, a life without the possibility of parole. Sorry about that.
Thank you.
Life without the possibility of parole. And that's, listen, the judge sentenced him from 30 to life, but I'm told that this particular judge really doesn't give you anything below life on a murder. So I think that's the expected sentence.
Yeah, so he gets either 30 years or life without parole. So either way, it's a death sentence behind bars, I guess.
His age, yeah.
Yeah. Given the family's long history and the prominence as local prosecutors, does that complicate where he actually spends time in jail? Does that come into play?
No, I think this is all about you are no different than anybody else. You are not above the law. And now that you are a convicted murderer, you're going to be among any other convicted murderer. And that's another issue, John, because had he been either if there was a hung jury or if he was not guilty, and then he was found guilty of some of the federal financial crimes, he had a possibility of spending his sentence in serving his sentence in federal prison, which is much better, especially on white collar crimes, than being in the population of murderers in a South Carolina prison. So that's obviously another huge consideration here.
Yeah, there's so much going on in this trial, and so much evidence, so much hearsay, well, not evidence, but a lot of testimony, and yeah, it's been an interesting 6 weeks. Sarah, thank you so much. It's good to see you. It's been so long.
John, take care.
You too. Bye. Well, in Iran.